Statute 397.501. We are discussing patient rights. Frankly, there's no more important subject than patients' rights. They've come a long way. What I'm going to do is I'm going to go through this. If I just read it, it's pretty boring. But the topic is not boring at all. In fact, it's extremely valuable. I will tell you that there's a lot of things under the behavioral health codes and licensing and certifications and all that is boring. This is not one of them. So we've got patient rights. We've also unlawful activities relating to assessment, treatment, and penalties. So right of individuals. Individuals receiving substance abuse services from any service provider are guaranteed protection of the rights specified in this section, unless otherwise expressly provided, and service providers must ensure the protection of such rights. So right to individual dignity, massively important. There's again, I can't stress to you how important all of this stuff is, and we're going to get into dignity and self-respect and the importance of family, and we're going to discuss consent and informed consent. Right to individual dignity. The dignity of the individual served must be respected at all times and upon all occasions, including any occasion when the individual is admitted, retained, or transported. Individuals served who are not accused of a crime or delinquent act may not be detained or incarcerated in jails, detention centers, or training schools of the state, except for the purposes of protective custody in strict accordance with this chapter. An individual may not be deprived of any constitutional right. So we're already discussing the fact that whether you are classified as mentally ill, a substance abuser, addicted, you are not a criminal. The two are not synonymous. Does crime happen with mentally ill people and people of substance abuse? Yes. But are they criminals overall? No. And that's a distinction right away. That when a person comes into treatment, they have to be treated as an individual case. Not all drug addicts are criminals, all mentally ill people are criminals. It just doesn't work that way. So number 2 on that is right to non-discriminatory services. They have a right like anybody else. They have a right, just like anybody else off the street. They have a right to treatment. They have a right to dignity and respect. They have a right to know what is going on. And I'm going to get to that because that's really the crux of this too. Service providers may not deny an individual access to substance abuse services solely in the basis of race, gender, ethnicity, age, sexual preference, human virus status, prior service departures against medical advice, disability, or a number of relapse episodes. A critical piece right there. Service providers may not deny an individual who takes medication prescribed by a physician access to substance abuse services solely on that basis. So if you're prescribed medication, you can't be denied treatment because of that. Maybe you'll get different medication, but let's discuss a couple of those bullet points that I just rattled off. So one of the things that I mentioned is number of relapse episodes. Very, very important. So in substance abuse treatment, generally speaking, a person that is a substance user or has a substance use disorder, sometimes known as SUD, is going to be in treatment probably half a dozen times. Typical age is going to be late 20s, early 30s, multiple treatment episodes, a long history of drug and alcohol abuse and use and dependency. So now the insurance companies may deny the benefit that the person has based solely on the amount of times the person has been to treatment. So they will deem that a person is not trying hard enough, is not motivated enough, is not optimistic enough, is not committed enough to the treatment plan that the treatment center has laid out. That in fact, the person is a malingerer, the person is faking, the person can do better. It has the implication that a drug-addicted individual is not a good person. It has the implication that a drug-addicted person has total control over whether or not they use drugs and alcohol, and it's not a disease, and it's really more of a moral and spiritual issue that the insurance company deems is just not appropriate, and therefore we're not going to cover, even though you have the benefit and you paid for it, we're not going to cover that service. And so that is a major issue in behavioral health, but something that a treatment center needs to be aware of, that a person that has been to treatment probably more than 3 times is going to be quote unquote red flagged by the insurance companies, and they may not be treated just based on the fact that they're a drug addict, which is wrong, completely wrong. The other thing is that it's very important that somebody with a virus, somebody who is has an immune deficiency, that it be documented appropriately. It's really not okay to write that a person has AIDS, that a person is HIV, and not attach explanation to it, history to it, or not say it in a way that's more protective of the individual. Remember that a person coming into treatment, it's the worst day of their life. You can say whatever you want. They're there because of consequences. They're there by their own choice. Their family forced them. They fell out of the sky. They rolled like tumbleweed, into the treatment center. It doesn't matter. The fact of the matter is that they are there, and they need the help that is required to get clean and sober. These individuals have every right as somebody else, and they shouldn't be treated less than, or it shouldn't be reported, because it could come back to haunt them, and it's a confidentiality issue. If they don't want that spread all over the place, then it's your job to protect them from that. Okay, each individual in treatment must be afforded the opportunity to participate in the formulation and periodic review of his or her individual treatment or service plan to the extent of his or her ability so to participate. This is section B. This is number 2 under non-discriminatory services, section B. And let me just say to you flat out, you can get rid of everything else. Pay attention to this. What they're talking about is what's called informed consent. If you don't provide informed consent, you're not a treatment center. If you don't provide informed consent, then you are basically talking to somebody on a park bench. If you don't provide informed consent, then you're not a professional. You're not. And that's plain and simple. Now, here's the deal. So, I used to run a family group. And this family group was made up of patients, and there was about 30 to 40 patients in this group, and another 30 to 40 family members that would come to this group. That's 80 people, roughly, 80 people in a group setting. What I would do is I would meet with the patients prior to the group, and there's a lot of things that go on in a family group if you didn't know that, but a lot of stuff. Confidentiality's at stake. Secrets are at stake. There's confrontation that could happen. There's breakthroughs, all kinds of stuff. There's communication that's never happened before. But here's the deal. One of the things that I did that was extremely powerful, that I I cannot say enough of is the fact that I told every patient in that room exactly what was going to happen that night as far as I was concerned. In other words, whatever technique I was going to use, whatever questions I was going to ask, whatever the format was, whatever the consequences might be, the emotional consequences might be of that night, I laid it out for each and every individual. I did the same thing with the families. And I informed them of what I knew best that was going to happen to the best of my ability. So, in doing that, you are creating trust with you and the individuals and the group and whatever else. You are asking them for their help. In other words, when you're saying, hey, listen, here's the deal, are you okay with this? They can say, no, I'm not okay with it. I'm not going to do that. I'm not going to sign this treatment plan. I'm not going to talk about the physical and emotional and sexual abuse that occurred to me when I was 10 years old. It's not going to happen. Okay, so that's not going to happen. Treatment centers and professional individuals run into problems all the time when they take informed consent for granted. Now, informed consent is a legal document. It's also an integrity contract, and I can't stress this enough. It's an integrity contract that says to the families and to the individuals and to the patients, listen very carefully. Here's what's going to happen in treatment. Here's how it's going to happen. And we think it's going to be successful. There's obviously, there's not a cure for the disease of addiction. And there's not a cure for mental illness. But we think, based on our stats and based on our success rates and family feedback and all that stuff, we think that what we're going to do is pretty good. And so, but here's how we're going to do it. Now, when a person signs that, they agree to that. They're full disclosure, right? That they agree to it. But the other side of it is they also agree to participate. You see, that's where the integrity, this concept that I have of this integrity contract that has to do with informed consent and all the other stuff comes into play. There's an unspoken integrity contract that must go on between a patient and the professional. If that integrity contract is not in place, treatment could be lost. Treatment will definitely suffer. Treatment will not be as effective. They need to be crystal clear. So this document, this section right here becomes vital. So let me move on, because there's more. There's obviously much more to it. Of course, is the policy of the state to use the least restrictive and most appropriate services available based on the needs and best interest of the individual and consistent with the optimum care of the individual. So what does that mean? Those are $25 words that mean that we're gonna take the least restrictive approach, right? We're not gonna hit you over the head with a hammer, and we're not gonna inject you with Haldol when it's not necessary, and we're not gonna make you, cluck like a chicken and, strip naked and do all kinds of crazy things. But we're going to do some group therapy and individual therapy and create a treatment plan and do things that we think will be effective in the least restrictive manner. We don't want to restrict the patient, right? We don't want to put them in 4-point restraints. That's not the level of care that we're really discussing here. We don't want to hurt the person. We don't want to hurt their chances of succeeding. And so the idea behind that is, let's try these different things that we think will be painless or relatively painless and probably will work. Each individual must be afforded the opportunity to participate in activities designed to enhance their self-image. Well, physical activity is great, group therapy is great, art therapy, those kinds of things to improve their self-image. It is a terrible feeling, and most patients feel this way. In fact, I don't know a patient that doesn't feel this way when they come into treatment, that that they think that they're losers. They think that no matter what they do, they're not going to succeed. Whatever voice inside of them that is telling them that is telling them that, and has basically been telling them that for years and years and years. So they have a right to participate in these activities, and so as a treatment center, you want to be able to to provide that. Right to quality of services. Each individual must be delivered services suited to his or her needs, administered skillfully, safely, in a humanitarian, humane way, with full respect for their dignity. Again, you have to file regulatory requirements as a treatment center and as an individual. Have to. That's why there are requirements. That's why there's law. You have to make sure the patients fully understand all of this stuff. In fact, I will suggest to all of you right now, go out to Office Depot. I was going to say Kinko's, right? But go out to Office Depot and make a patient right form that is the equivalent of your ceiling to your floor, right? And it takes up the whole wall. Do it. There'll be a list of things, number one, patient rights and accountability and informed consent. Top to bottom, big, bold letters, so that the entire treatment center can see it. That is what you should do. Don't hide it behind the kitchen sink. Don't put it in your office behind your picture of the dog. Don't put it in the group room where it's going to fall off anyway. And certainly don't hand it out because nobody reads it anyway. Make sure they sign it when they come in, and they sign it on their documents, and make sure that it is out there in color-coded 3D huge lettering that not only they can see, families can see, visitors can see, and it basically tells the world, I am pro-patient, which leads me to this thing. So, what do we call somebody who comes into treatment? And it has to do with everything that we're talking about. I'm gonna tell you a story. So, do we call them clients? Do we call them patients? Do we call them by their name? Do we call them... What do we call them? Many, many years ago, I would say about 20 to 25 years ago, when the states were still battling between what should we fund, substance abuse or mental health or both, and so the governments, the state governments, came up with a word. This was actually in 2000, year 2000. They came up with a word, and they said this is what you should call all patient and clients moving forward. It identifies them so everybody knows who we're talking about, and that word was a consumer. That they were a consumer. Are you kidding me? A consumer? What are they buying? Consumer of what? So what I did was I remember I was running this long-term mental health facility, and I met with the patients, schizophrenics, bipolar, depression, who've been in treatment their entire lives. These were adults, treatment their entire lives, patient their entire lives, institutionalized. And I said, listen, there's this state mandate that's come down that says that we got to call you guys consumers. And I remember this one guy raised his hand, and he said, what are you buying? Why don't you call me by my name if you're going to call me anything? And he was right. And I remember we wrote letters to the state. Eventually, cooler heads prevailed. Somebody got sober and realized that was kind of stupid, and it was really not appropriate. And so What do you call them? You call them patients. They are your patients. That's what you should call them. So I just want to be clear about that. The department must specify by rule the methods that may be used and the techniques that might be applied by service providers to control aggressive behavior, and must specify by rule the physical facility requirements, seclusion rooms, all of those, the dimensions, the safety features, all of that. So again, goes back to informed consent. Even if a patient is psychotic, even if a patient is completely out of their mind, they're not medicated right, they still have rights. You can't beat them up. You can't just throw them in a room. You can't just treat them like animals. Even the seclusion rooms that do have 4 and 5 point restraints, there has to be monitored. There has to be documentation. There has to be the right medication approach, the right type of staff and staff patterns. Even the room itself, the dimensions need to be correct. You can't just have this ice box or this throwaway room that nobody uses. That's just not okay. Unfortunately, there are treatment centers that practice that. Right to communicate, right to communication. Each individual has the right to communicate and freely and privately with other persons within the limitations imposed by the service provider policy. Moving along to, because the delivery of services can only be effective in a substance abuse-free environment, close supervision of each individual's communications and correspondence is necessary, particularly in the initial stages of treatment, and the service provider must therefore set reasonable rules for telephone, mail, visitation rights, giving primary consideration to the well-being of the individual. It is the duty of the service provider to inform the individual and his or her family at the time of admission about the provider's rules. So again, all about informed consent. Whatever the rules are, lay it all out. There's a reason that you don't want people communicating on their cell phone like they were prior to coming into treatment, because that's not treatment. That's your addiction. That's your old behavior. If you give somebody their phone, nowadays, the phone's a weapon. The phone's a drug. Forget it. They might as well not be in treatment. So you have to lay it all out, what the rules are, and explain to them why. Now, this is great because once you do and they resist, you know that you've hit pay dirt, and you know that there's levels of acceptance that this individual has or doesn't have, and that's therapy. That's therapeutic. You can discuss that and negotiate that with the individual and their families. So don't be afraid to do that. Right to care and custody of personal effects. Any individual has the right to possess clothing and other other personal effects. The service provider may take temporary custody of the individual's personal effects only when required for medical and safety reasons. With the reasons for taking custody and a list of personal effects recorded in the individual's clinical record. Again, don't just take things just because you're going to take them. There has to be everything has to have a purpose to it. Right to educate of minors. Each minor in a residential service component is guaranteed education and training appropriate to his or her needs. The service provider shall coordinate with local education agencies to ensure that education takes place. In other words, they can get to go to school. Again, not criminals. They should actually be in school when they're in treatment as adolescents, because they probably are going to pay attention more and maybe focus more as well. This chapter does not relieve any local education authority of its obligations under law to provide a free and appropriate education to every child. So you got to educate them. Right to confidentiality of individual records is a big one. This is a big one. People want to know what the heck you're talking about and what you said about them. They think that there's some mystery to it, but really there's not. So, right to confidentiality of individual records. The records of service providers which pertain to the identity, diagnosis, and prognosis of a service provision to any individual are confidential in accordance with this chapter and with applicable federal confidentiality regulations, and are exempt from. I'm just going to quote some scripture here. 119.071 and 24A.1 of the state constitution. Such records may not be disclosed without the written consent of the individual to whom they pertain, except that appropriate disclosure may be made without such consent. Number 1, to medical personnel in a medical emergency. Number 2, to service provider personnel if such personnel need to know the information in order to carry out duties relating to the provision of services to the individual. Number 3, to the secretary of the department or the secretary designee for purposes of scientific research in accordance with federal confidentiality regulations, but only upon agreement in writing that the individual's name and other identifying information will not be disclosed. Number 4, in the course of review of service provider records by persons who are performing an audit or evaluation on behalf of any federal or state or local government agency or third-party payer providing financial assistance or reimbursement to the service provider. However, reports produced as a result of such audit or evaluation may not disclose names or other identifying information and must be in accordance with federal confidentiality regulations. Let me tell you how important that whole passage was. If you don't know, hire somebody to help you. Don't rely on, I got it, I know. Confidentiality is a sensitive area because information is power and control, and it's knowledge, and people will pay money for people's personal information. You must not divulge personal information unless you are absolutely sure that you have everything signed off on and everything is appropriate. Another way is upon court order, right? Based on application showing good cause. You can't just go to a judge and say, I need to know about John because I don't like him. That's not how it works. Restrictions on disclosure and use in this section do not apply to communication from provider personnel to law enforcement officers, which, 1, are directly related to an individual's commission of a crime on the premises of the provider or against provider personnel, or to the threat to commit such a crime, and 2, are limited to the circumstances of the incident, including the status of the individual committing or threatening to commit the crime. For example, if somebody pulls an alarm, a fire alarm in a treatment center, the cops are called. Yes, if the person is found guilty, all of that stuff, but they don't need to know this guy's history. That doesn't make any sense. So moving right along. Let's see, 2, are limited to the circumstance. We said that. C, the restrictions on disclosure and use in this section do not apply to the reporting of incidents of suspected child abuse and neglect to the appropriate state or local authorities as required by law. However, such restrictions continue to apply to the original substance abuse records maintained by the provider, including their disclosure and use for civil or criminal proceedings which may arise from the report of a suspected child abuse or neglect. Any answer to a request for disclosure of individual records which is not permissible under this section or under appropriate federal regulations must be made in a way that will not affirmatively reveal that identified individual, right? or diagnosis or treatment or substance use or anything. The regulations do not restrict the disclosure that an identified individual is not and has never received services. Since a minor acting alone has the legal capacity to voluntarily apply for and obtain substance abuse treatment, any written consent for disclosure may be given only to the minor. This restriction includes, but is not limited to, any disclosure of identifying information to the parent, legal guardian, custodian, minor for the purpose of obtaining financial reimbursement. When the consent of a parent, legal guardian, custodian is required under this chapter in order for a minor to obtain substance abuse treatment, any written consent for disclosure must be given by both minor and the parent, legal guardian, or custodian. Okay, I hope that's clear as mud. We are now going to page 4. An order of a court of competent jurisdiction authorizing disclosure and use of confidential information is a unique kind of court order. Its only purpose is to authorize a disclosure or use of identifying information which would otherwise be prohibited by this section. Such an order does not compel disclosure. A subpoena or a similar legal mandate must be issued in order to compel disclosure. This mandate must be entered at the same time as and accompany an authorizing court order entered under this section. Hire an attorney is what I'm telling you to do. An order authorizing the disclosure of individuals' records may be applied for any person having a legally recognized interest in the disclosure which is sought. The application may be filled separately as part of a pending civil action in which it appears that the individual's records are needed to provide evidence. An application must use a fictitious name, very important, such as John Doe or Jane Doe, to refer to any individual and may not contain or otherwise disclose any identifying information unless the individual is the applicant or has given a written consent to disclosure, or the court has ordered the record of the proceedings sealed from the public scrutiny. Okay. The individual and person holding the records from whom disclosure is sought must be given adequate notice in a manner which will not disclose identifying information to other persons, and an opportunity to file a written response to the application or to appear in person for the limited purpose of providing evidence on the statutory and regulatory criteria for the issuance of the court order. Any oral argument, review of evidence, or hearing on the application must be held in the judge's chamber or in some manner which ensures that identifying information is not disclosed to any other party. A court may authorize the disclosure and use of records for the purpose of conducting a criminal investigation or prosecution of an individual only if the court that all of the following criteria are met. Number 1, the crime involved is extremely serious. It has to do with homicide, sexual assault, sexual battery, kidnapping, armed robbery, assault with a deadly weapon, child abuse, and neglect. Number 2, there is reasonable likelihood that the records will disclose information of substantial value to the investigation. Number 3, other ways of obtaining the information are just not available or would not be effective. Number 4, the potential injury to the individual, to the physician-individual relationship, and to the ability of the program to provide services to other individuals is outweighed by the public interest and need for disclosure. Okay, right to counsel. Each individual must be informed that he or she has the right to be represented by counsel. in an involuntary proceeding for assessment, stabilization, and treatment. Right to habeas corpus. At any time and without notice, an individual involuntarily retained by a provider or the individual's parent, guardian, custodian, or attorney on behalf of the individual may petition for a writ of habeas corpus to question the cause and legality of such retention and request that the court issue a writ for the individual's release. This is extremely important. This goes back to all the patient rights that we're talking about. Liability and immunity. Service provider personnel who violate or abuse any right or privilege of an individual under this chapter are liable for damage as determined by law. All persons acting in good faith, reasonably, and without negligence in connection with the preparation or execution of petitions, applications, certificates, or other documents, or the apprehension, detention, discharge, examination, transportation, or treatment of person under provisions of this chapter shall be free from all liability. Very important, that key word, acting in good faith. What was your intention? As a professional, what's your intention? Knowingly furnishing false information for the purpose of obtaining emergency or other involuntary admissions for any person is a misdemeanor of the first degree, punishable as provided in section 775.082 and by a fine not to exceed $5,000. Basically, you can't go to a judge and say, John Smith's crazy and he needs to be locked up. And they're, okay, that's not going to happen. Causing or otherwise securing or conspiring with or assisting another to cause or secure without reason for believing a person to be impaired, any emergency or other involuntary procedure for the purpose is a misdemeanor of the first degree, punishable as provided in section 775.082 and by a fine not to exceed $5,000. Causing or conspiring with or assisting another to cause the denial to any person or any right accorded pursuant to this chapter is a misdemeanor of the first degree, punishable as provided by section 5.82 and by a fine of not to exceed $5,000. That is the conclusion of patient rights.